Thank you. Mark Richard, Phillips, Richard, and Wren, attorneys for AFSCME 1907. Thank you, and I think some questions were asked earlier that are fair questions. Been a labor lawyer. We represent over 80 unions here, born in South Florida. We've done a lot of unit clarifications before, and there are absolute criteria. You come from the school system. It's exactly used by every public employer, and it's exactly what the manager and the city attorney and the union attorneys did in this case. So one of the big questions, and Sean is up here, Mary's with me, one of the big questions that came out in 1975 when public employees were allowed by Constitution and by statute, Chapter 447, to form unions was going to be who was going to be in the unit, which job classifications, not people, this is not personal to people, and who would be out. And it became very clear that if you are a managerial employee under Florida statutes, you can't be in the union. You can't be in the union if you have job titles and job duties that cause you to form policies about collective bargaining, or you get involved with someone's ultimate decision to be terminated. The city attorney can't be in our unit. And so the statute is very clear. It lists about 7 things, and if any one of those are met, you are not eligible. That classification is not eligible to be in the bargaining unit. And so while folks are asking, so what happened here, it became clear that there were hundreds of job classifications that needed to be in the bargaining unit. Whether they choose to be in the union or not is a completely irrelevant, separate question, although we hope you earn that trust. As a result, PERC in the 70s, the Public Employee Relations Commission, is a 3-person group appointed by the governor that oversees all this. And in the 1970s, they used to say, when you describe your unit, you don't have to list every single title. You can have an umbrella, generic description is what we have here. Professional general employees are in Sean's unit. So then we went originally and looked at hundreds of job classifications and what people do, both. And originally, we were talking about 321 job classifications that should be in the bargaining unit. And we painstakingly went page by page by page. I can't tell you how many meetings. That's the kind of criteria, and followed the law to the T. Eventually, 321 classifications that were not in the unit now became eligible to be part of the bargaining unit. At the same time, you decide, are those people, separate issue, going to be classified or unclassified for civil service? It's 2 parallel questions. They affect each other, but they're separate. And those were decided. Then a problem happened. There were arguments over whether or not of the 321 classifications, were they all to be also classified employees for civil service purposes. And that led to a disagreement, intellectually honest, legally based disagreement. And it ended up going into court, because we had already settled on the bargaining unit. PERC didn't get involved. The parties settled it. We filed a lawsuit. This manager, this city attorney, this union attorney sat down. These people all had input. People have known all about this for more than a year. It applied Chapter 447. And in doing that, we worked out what would be the class these people would be classified. And it became clear that there were 31, less than 10%, 31 positions that should not have been in the bargaining. They get involved in collective bargaining. They help prepare for the city, prepare for an grievance against Sean. Florida law logically says you can't, that conflict of interest. So they were managerial employees. The test, it literally says they prepare budgets. They prepare mathematics for bargaining. You're not going to be able to prepare mathematics and budgets for bargaining and then be in the bargaining unit. You don't want that. This law was put in really for management to make sure you have a pool of managerial employees. So the 31 classifications out of 321 should not be in the unit. And so we've settled the lawsuit, we've saved the money, we've applied the law, we've done it correct. Your lawyers pushed us to the edge, your manager pushed us to the edge, we pushed to the edge to do it right. It's right, and we're asking you to resolve what has been several years. Everybody who spoke to it has known about it. Everybody's had their input. This is a very fair, legally based, correct resolution. Look for support of what has been worked out appropriately between the parties.
Thank you, sir.
Thank you.